Pete Canalicchio presents
Licensing Contract Negotiation Process. Stage 4. Drafting the Agreement. Once senior management have given the deal the green light, and the deal terms have been agreed upon and signed off between the licensee and the licensor asks their legal counsel to draft the contract. The deal terms summary sheet provides the material for the contract. While there are many versions of licensing contracts, best-in-class contracts contain the following provisions. Schedule A, Standard Terms and Conditions. Schedule B, Scope of License. Schedule C, Royalty and Payment Terms. Schedule D, Submissions Notice. Schedule E, Manufacturer Agreement. Schedule F, Quality Standards. Schedule A, Standard Terms and Conditions. Schedule A contains all the standard terms and conditions of the licensing agreements. The standard terms are the contractual guts of the contract, and as such, there is little room, if any, for negotiation. Schedule A covers which parties are entering the agreement and the reasons for doing so. It covers what is granted, the quality requirements, and the approvals required to ensure that they meet those requirements. The standard terms and conditions cover royalty payments and provisions to verify those payments were made accurately. This section covers who owns the intellectual property created and what expectations are put upon the licensee to market the covered products. It covers the term of the agreement, termination provisions, and the effect of the termination. The remainder of the agreement is typically referred to as the licensor's boilerplate. While most of the discussion in these remaining sections will be between the attorneys from the respective parties, there are a few of these sections that will be of equal interest to the business professionals. These include change of manufacturing, unfair labor practices, customer service, and change of control. While the standard terms and conditions portion of the contract can be the most tedious to read through and comprehend, it is critical that members from both organizations familiarize themselves with them. This will help ensure each party adheres to the stipulated language and will position the relationship for successful execution. Terms included in this schedule are definitions, license grant, marketing and sales, quality control and compliance with laws, approvals, royalty payments, records and auditing, trademark rights and work product, term, termination, effective termination/expiration, representations and warranties, assignability/change of control, governing law, jurisdiction and venue, infringement by third parties, insurance, manufacturing and authorized manufacturers, confidential information, unfair labor practices/human rights, press releases, customer service, indemnification of licensee and use of licensee's name, notices, force majeure, waiver, severability, no agency created, survival of provisions, counterparts. Schedules B and C. Schedules B and C recap the terms that affect the day-to-day servicing of the license and should be understood thoroughly, not just by the person who negotiates them or signs the contract, but also by the people who will be involved in the business planning and operations of commercializing the licensed products. These schedules should always be near at hand for the people involved in the daily operations. Schedule B, which is provided in Appendix 4, Schedule B, contains terms related to the scope of the license including trademarks, covered products, authorized channels, territories, contract term, insurance requirements. Schedule C includes terms related to royalty and payment terms, marketing and sales, and shipping and commercialization. Schedule C can be found in Appendix 5, Schedule C of Contract. These terms include definition of net sales, royalty rate, advances, guaranteed minimum royalty payments, transfer fee for approved assignments / change in control, payment instructions, schedule of minimum product introductions per year, sales performance requirement, shipping date, commercialization date. Schedules D, E, and F. Schedules D, E, and F contain standard contract language that is usually not negotiable. The provisions are generally to protect the brand and the company. Schedule D contains a submissions notice. The submissions notice is the licensor's requirement for how they want the concepts, prototypes, and final production samples submitted. Schedule E is the manufacturer agreement. This provision is used when the licensee does not own the manufacturer. In this case, the manufacturer agreement states that any third-party manufacturers used by the licensee will be audited prior to employing their services to make sure the manufacturer meets the standards set by the licensor. Schedule F covers the quality standards that must be followed for all licensed product being sold under the licensor's name. This section typically includes testing standards for each of the covered products and what testing facilities can be used to evaluate that the approved products pass those standards. Passing the testing standards keeps the product from being recalled, which is critically important to the licensor.
You were listening to a Pete Canalicchio production. Grab valuable resources from brand licensing experts for 100% free today. Are you interested in extending your brand's influence, strengthening consumer relationships, and generating unlimited revenue from guaranteed royalty payments? Get your free membership today. Visit PeteCanalicchio.com /fast-track.